Good afternoon to the colleagues of the LPC and to Advocate Hussein. We thank you, Advocate Hussein, for allowing to taking time out of your busy schedule to come and present this webinar to the pupils. Pupils, we just want to announce that this session will be recorded and will be made available upon request. If you send an email to info@lpc.org.za. I'd like to hand over to Advocate Hussein. Advocate Hussein is also the drafter of the syllabus of the pupil examination that you will be sitting down for in September, and is also one of the markers and the moderator. Advocate Hussein, I hand over to you.
Okay, thank you, Margaret. Just one question. I'd like to take questions at the end of my session. How are we going to do that? Are they going to be sending you written questions, which you will then send to me? How do you intend to do it?
Sonny, can you please come in here? How are you going to facilitate? Are they able to unmute their mics?
Yes, their mics are muted, but what happens is maybe me or Mr. Nwaba would be reading out the questions after Mr. Hussein has finished with his presentation.
Good. Okay. All right, let's get started. Good day and welcome to all of you. Must be a very exciting time for you that you've gone through an LLB, you've gone through pupillage, and you're at the cusp of starting your careers. It's really an exciting time, and I want to take you through the exams or the assessments, as it's called in the Act, and give you some information that will help you not only to prepare, but also to write the exams. This workshop is arranged by the LPC, and usually Margaret and Mr. Molefe will usually set this up, and we've had quite a lot of people attending it and benefiting from it. So let's get started. In the past, when I say past, I mean pre-2018. What happened? Sorry, I just need to switch off my email, which is now making a sound. Okay, what happened is that the bar meant you had to be part of the General Council of the Bar, one of their constituent members, like the Society of Advocates of Johannesburg, the Cape Bar, and so on. Then things opened up after 1994, and we had various bars coming out, and they became known as the independent bars. And regulation and control of this process was not working out too well. But then we brought in the Legal Practice Act came in, and now we have a single regulator, the Legal Practice Council, and the qualifying exams are administered by the LPC, both for attorneys and advocates. The GCB still has its own exams, and those of you who are with the GCB will still be writing 2 exams. But the qualifying exam is this one. Okay. So if you don't pass this exam, you can't be admitted as a practicing advocate. The Legal Practice Act did away with this practice we had pre-2018, where one could actually register or be admitted as an advocate just with an LLB. You didn't need to do pupillage and pass an exam. Well, that has changed now. For the good, I must tell you, it's worked out very well. And in order to administer these exams, a number of steps were taken, which were new, and we hope that the whole process will improve as the years go by. But so far, we've written, I think, 9 national bar exams, and we've had no complaints, nothing. If you look at what the attorneys have been doing, they still have the old system, which is not even a system. We get complaints in the hundreds coming after every paper. So that has not happened, which is a good, with the advocates, which is a good sign. So Section 26C of the Legal Practice Act requires pupils and candidate attorneys to undergo practical vocational training. Now, practical vocational training is split into 2 parts. The one is the training you get during pupillage, going to court with your pupil masters, drafting papers, attending motion court, all of those practical things that you do. That's one component of vocational training. The other component is to comply with the syllabus, which is based on the regulations, and the coursework that is actually prescribed. It's prescribed by the Legal Practice Council, and you are expected to study the coursework as prescribed. That is followed by a competency-based examination. And that's an important description. It's not merely an examination. It is meant to do an assessment of your vocational training. So this is not academic stuff. It's not LLB. We want to test your ability to practice as an advocate. Okay. And that requirement is, you will see, is well represented in the syllabus as well as the assessment exams, or the assessments, the competency-based examination. But what we didn't merely give you a syllabus. By the way, the syllabus is supported by what we call norms and standards. The Legal Practice Act requires the Legal Practice Council to set norms and standards for the profession, and those norms and standards support the syllabus that was produced. Now, what goes with that syllabus is the very important reading list, which you're all familiar with, I hope. So actually, if you're not familiar with it, you shouldn't be attending this program. It's too late. The point is, if you looked at the reading list, it is packed with case law. Why is that? Why is that so? When you practice as an advocate, please remember one thing. The law that you apply in the cases you deal with, be they trials, appeals, motions, opinions, in practice, there are only 2 sources of law that really matter to an advocate. And these are what we call primary sources of law, and they are legislation and case law. We have a system of binding precedent in our country. It's called the common law system. So the law is what the courts say is the law. What a textbook says about the law is merely persuasive. It does not bind a judge. What binds a judge is what the cases tell the judge. If there's a judgment of an equivalent or higher court, that binds the judge. Now, as a practicing lawyer, the only authority that matters to you and to your client is case law and, of course, statute. Okay? Forget about everything else. That is why, when you look at the reading list, you will see cases. Now, it is very much a part of vocational training that advocates need to know where to find the law, how to find it, and how to use it. That's another way of saying you must know where to find the cases, how to extract the rule, the legal rule from the judgment, not from a textbook, from a judgment, and then apply it to the facts of your case. That's what lawyers do. So, if you read through the reading list, you will see that we referred you to judgment after judgment. But we made it a bit easier for you because we gave you the paragraph in the judgment that you should read. There are some judgments that are absolute classics and you need to know, read through the whole thing, then you will read the whole thing. But we referred you to those paragraphs. If you've read through those cases and understood the legal rule or the point that was being made, you're going to pass the exam. Simple as that. Okay? But if you didn't read any cases, you've missed out on probably the most important component of vocational training for an advocate. An advocate is useless if an advocate doesn't know where to find the law, which is binding on the judge. And just remember, these days, all you need to succeed in a case is to find the most recent decision of the highest court. One judgment. That's all you need. Judges don't want you to give them lists of case authorities anymore. Those of you who read the rules of the SCA and the Constitutional Court, you'll see they say that you must support your legal submission with reference to one case, one judgment. And if you need to quote more than one judgment, you must give a reason for it. Okay? So let's get back to the Act. The purpose of the assessment for the council is to establish that the pupil has attained an adequate level of competence to be enrolled as a practitioner. That's a quotation from section 28. An adequate level of competence. Remember, it doesn't take more than that. You are pupils, you're lawyers, you're young lawyers. You will, as lawyers, you will never know everything, okay? It's a vast area. Look, one day when you become a magistrate, you'll know everything, but until then, you don't know everything. What we're looking for is a reasonable level of competence that is displayed in the manner in which you answer the questions in your exams. And I will take you through that process. The regulations I mentioned already, Regulation 7 provides the structured coursework. Now, the syllabus that you've got, that you're familiar with, is based on the regulations. It sets out a number, I think it's about 11 different subjects that you must be familiar with. And that is then supported by the reading list. The regulations also require that the coursework must be supported by a set of norms and standards. That's also in the syllabus and reading list that you have. Now, the LPC has in consultation with the profession, developed this curriculum and the reading list and published it. It sets out the content of the coursework and prescribes a reading list that supports the coursework. Now, we being typical advocates here, the supporting authorities is case law. It is also legislation, but you're hardly going to be tested on legislation because legislation merely describes the law as it's enacted by Parliament. What's important for lawyers, advocates, is to see how that legislation is interpreted and applied to a factual situation. That happens in a judgment of the High Court. And the judgment you want is the most recent decision of the highest court. Always remember that. And I've put a comment here. If it is not in the syllabus, if it's not in the reading list, it will not be in the exams. Simple as that. So you don't have to speculate about what's going to come out in the exams. I think it's a good idea to look at the past papers. There aren't very many of them because, we only started this thing about 2021 or 22. And so there's about 9 different sets of papers. It's a good idea to go through it because it gives you a feel of how we ask questions. And I'll get to the structure of the questions in a moment. So the reading list plays a critical role in training advocates. Advocates have to research the law. And I'm repeating, the advocate's most important law is case law, primary sources. Forget about secondary sources. The secondary sources are there to assist you with understanding general principles. That's what textbooks do. But textbooks are also important for you to, they refer you to case law because the textbooks are based on case law. So if you can't find the judgment, go and read the textbooks. It'll refer you to a judgment. Then you go to the judgment, check the annotations, and you'll find the most recent case of the highest court. So knowing how to find and read and apply case law is a fundamental skill. And I call it a vocational skill. It is a vocational skill. There were colleagues or there were members of the profession who said, why is there so much case law here? I had to explain to them, it's because that is the law. Okay. And why is it a vocational skill? Because you can't practice without it. It's like a carpenter arriving to build a cupboard, but he doesn't have a saw. He doesn't have tools. The cases represent the tools of your trade. Don't forget it. Always focus on understanding the underlying principle. Now, this doesn't come easy. You learned at university, for example, that what's important in a judgment is the ratio decidendi. Lecturers like saying ratio decidendi. It makes them sound very important. They don't know what it is. Have you asked a lecturer at university, excuse me, can you tell me how do you work out the ratio? They won't tell you. They won't be able to tell you. Nor does a judge writing a judgment put in a neat little heading that says ratio decidendi and then writes it. It doesn't work out like that. You have to read the whole case and work out how the judge arrived at the decision by applying what principle of law. A useful trick is for you to look at a judgment, go to the annotations, find the next judgment where it was referenced, read that judgment. Another judge will tell you what a ratio is in this judge's judgment. There's a comment I read somewhere that the ratio of a case is what another judge says it is. So you need to understand the underlying principle. Otherwise, there's no point in reading a judgment. You need to see the reasoning behind the rule. And let me explain something to you. Those of you who are going to be practicing advocates, just remember one thing. Everything you do as an advocate involves thinking. Okay? Do not indulge in copying and pasting. You can use AI if you like, but AI is not a new source of precedents that you can copy and paste. Advocates, there's a big difference between what an advocate does and what attorneys do. An advocate thinks through everything that you do, everything that you write. There must be a reasoning behind it. You must apply logic. Now, one of the things that for a practicing advocate is that before you look for the law in the law reports, in the cases, you first have to know the facts. That's the difference between academic law, which you studied at university, and applied law is what you're going to be practicing for the rest of your careers. One thing you didn't do at university is that no one told you that in any legal dispute, the most important component is not the law, it's the facts. When you have the facts, now look at the law, because you want to find a judgment that is supported by the facts of your case. Otherwise, it's useless. It's not binding. You know that whenever you give a judge a judgment and say, my lord, here's the authority, the judge will say, listen, is it not distinguishable on the facts? If it is distinguishable, you slipped up, you see? So you need to understand the facts of your case first. Now look at the law. So let's talk a bit more about the assessments. The curriculum and the reading lists were very carefully put together by the LPC. It is intended to set a standard according to the norms and standards and to attain vocational skills. It's all designed to give you vocational skills. You, for example, will have to write an exam on legal writing. You'll be drafting particulars of claim, notices of motion, drafting heads, founding affidavits. That is one of the vocational skills that you will require, and it's a 5-hour exam. So what we want to look for is an assessment of vocational skills. In other words, if you've been through the past papers, you'll see that you are given a problem in the form of a set of facts. And then we say, how would you advise your client? Or what relief would you seek? And you'll be asked to draft papers. That is what we're looking for. We're looking for your ability to know what to do, how to do when presented with a problem by your client. So the point is, if it's not in your syllabus or reading list, it won't be assessed. You can be sure about that. So there'll be no surprises in your exam paper. You see, when you have a syllabus, it provides direction, it guides you. The pupils no longer have to nervously speculate about what will come in the exams. However, sometimes it happens where during the year comes a judgment that is precedent setting. Everyone's talking about it. We might set an exam question on that judgment, but we know it's not in the reading list. When that happens, we will give you a copy of the judgment. It will be attached to your exam question paper, and we'll give you extra time to read it. You'll get extra reading time. So that rarely happens, but sometimes it does. So we're fair to you. We know it's not in the reading list. You may not have been aware of this judgment, so we'll give you a copy of it. Okay. Now, the examinations themselves, a lot of hard work and thought goes into it. There's a process of setting to start with. Then there's moderation. Then there's marking. Then there's moderation of the marking. Okay. So the LPC sets the standards for assessments. They have to establish clear marking criteria and templates. So that's what we do. Now, as we all know, with legal questions and legal problems, there is often not a single right answer. Okay, it's not like science. However, we are looking for an answer that will deal with certain key points. If those key points are there, the pupil passes. Okay, it may not be the way some of the markers would have liked it. Each marker has their own style and so on. So we try and control that. So we don't have extremes in marking. So firstly, we train the setters, are trained people. Moderators are trained. And when it comes to marking, we train the markers together. And we say, this is the standard we need you to apply. And we give them a template to guide them. And the template is not a model answer. It is the main points that should come out in that answer. So if it's written in a different style or the paragraphing is not the way it's normally done, as long as the main points are there, the pupil will pass. I can assure you, we understand that many of you are writing in a language that's not your first language. So the markers are trained not to penalize you for spelling errors, for grammatical errors, for lapses in expression. We don't mark you down for that. We're looking for the legal principle. We want to see that you recognized an issue in the facts of your matter. Then you applied the law to those facts and you came up with an answer. It can be drafted, if it's drafted inelegantly, you're not going to get marked down for that, okay? All question papers are subject to moderation. The person who sets the exam does not moderate. So there's a completely different independent person who moderates. So the moderator will look at things like ambiguity in the question. Is there a bias in the question? Very importantly, we make certain that the question is written in plain language and is easy to understand only in one way. So there's no ambiguity in the questions. The setter is alive to that, but an independent moderator will look at it and say, well, look, this thing is a bit ambiguous. It could mean one thing or the other. Okay. The exams must be based on the syllabus. In other words, it must be relevant to the syllabus and the reading list. That is the content that must be covered. So we use two independent markers who don't see each other's scores. So basically one person is marking, then it goes to a moderator who now looks at this and sees that the mark allocated to the pupil is a fair mark. Okay. We use senior practitioners. We'll have part of the moderation process is to do random sampling. We will take scripts at random to see if the marking is fair and that the scores were fairly allocated. The markers themselves undergo training, and they are all senior practitioners. And I can tell you this includes a number of silks, senior counsel. You know, I was reading a book on Einstein's. I was reading a biography of Einstein, Albert Einstein. And someone asked him, can you define a good question? And he gave a definition, which I was so impressed with, I tell all my pupils about it. He said, a good question is one that is understood and it has an answer. Think about that. A good question is one that is understood and it has an answer. Okay. Let me give you an example of a bad question. I'm sure some of you here are unfortunate enough to be married. Well, my wife, Mrs. Hussein, often says to me, you know, when she's dressing up for one of her weddings in her family, which I hate, she'll put on a dress and say to me, listen, do I look fat in this dress? Now, that's a bad question. Firstly, it's not a question you can understand. And secondly, it has no answer. Because no matter what answer you give, it's bound to be wrong. If you say, oh, no, you don't look fat in that dress, she says, you're a liar. I do look fat. Well, if you say, oh, yes, dear, you do look fat in this dress, then you're an insensitive swine. You see, there's no right answer. We do not allow questions like that in the exam. No ambiguity. You'll understand it first time in only one way, and there is an answer. You don't have to speculate. If you know the answer, you put it in your script, you pass. Simple as that. Okay. So I mentioned that the exams are set, then moderated, marked, then moderated. We're looking for fairness, good standards. The assessment, the exam itself must be aligned with the learning objectives and outcomes. You see, the learning objectives and outcomes is vocational skills. It's not academic skills, it's vocational skills. Your ability to apply your mind to a set of facts, find the applicable law, and come up with an answer. That's what it is. It is an assessment of those skills, okay? So the exams themselves, you will write 5 papers, motion court proceedings, paper 1, and information and communication technology. The paper itself is weighted heavily in favor of motion court, obviously, because what advocates do on a daily basis, it's your bread and butter, is motion court proceedings. Then we have trial court proceedings and ADR, which is paper 2. Paper 3 is criminal procedure. Okay. Paper 4, ethics and constitution constitutional and customary law. Now, some of you by now would have read the Code of Conduct for Legal Practitioners. It's an enormous document. It is so comprehensive that it deals with every possibility or contingency that can arise during practice. It's very well written, it's very comprehensive, and it's long. So what we do in fairness, if we ask a question on ethics, and there is an applicable code, we give you a copy of the code. It'll be attached to your script. So you are not expected to learn off the code. By the way, you're not expected to swat off anything. All you need to do is read the code, understand what the principle is. And paper 5 is the legal writing and drafting. And for each of these papers, you will be given reading time. When you get your script, right at the top, it will tell you how much reading time there will be. If we gave you a judgment, a new judgment, which is attached, if we gave you a lengthy code, which will be attached, we give you a extra reading time. Now, Margaret would have circulated a format of the exam to you. Read that carefully. That's where the information is. Now, let's get back to vocational assessments. The compulsory coursework and pupillage is there to provide vocational training. I've emphasized that. Therefore, the exam is about making an assessment of those skills. So firstly, we discourage learning by rote. You did that at university, where you swat something and then hope it comes out in the exam and then regurgitate it in the exam room. That you can get away with that in the academic world. But you're in practice now. You've grown up. What you want is to apply your skill in analyzing and understanding the facts that are presented to you. Then work out what the issue is. Then find the relevant case. Then come up with a solution. This swatting and regurgitating doesn't work. By the way, you can take it that you will not find questions in this exam which is conducive to learning by rote. We don't ask questions like that. You'll never see a question that will say, write a short chapter for 15 marks on the duty of care. You won't see that. But you will find a question of delict that will test your knowledge of duty of care, but in a practical way. Okay. The emphasis is on understanding, on problem solving, and knowing what to do, how to do. That's it. There is no essay type questions there. It's not there. You can expect that there will be questions that require you to apply your knowledge and skills to everyday type problems that come up with a brief. Now, those of you who went through the past papers, you'll see that many of these questions are based on everyday problems. In fact, all the past papers, we came up with questions, a set of facts that actually happened, that you would have seen in the media, you would have read in a law report. So There is no essay type question, okay? So what do you have to do? Firstly, you need thorough preparation. Now, if you read the cases, but read actively, in other words, you didn't skim read it or copied and pasted it somewhere, you actually read it, understood the point. You applied your thinking skills. Why is this the principle? How can I apply it to the facts of my case? Will the remedy that I want be supported by the facts and the law? That's the kind of thinking we're looking for. You will also require an effective examination strategy. We are going to deal with that in a moment. But as an advocate, you must learn to read actively. You know, there are two kinds of reading. There's passive reading, where you can skim through page upon page and page, and then find that you can't remember anything. It happens to all of us. We all end up sometimes reading passively. You never do that as an advocate because you'll be wasting your time. You need to read actively. Think as you read. Concentrate on the text. Keep asking questions. Is this relevant to my problem? Why is this supported by the facts of the case? What is the legal principle? Can I apply it to my facts? Okay. Finding the legal rule is an important vocational skill. Now, there are two skills. The one is being able to analyze your facts, the peculiar facts of your case, and being able to work out what the factual issues are. Then you go to the law. You never look at the law first, then the facts. That's putting the cart before the horse. Stupid lawyers do that. Get the facts first, analyze, understand, work out what's your case concept. Now look at the judgments, okay? Then you apply, when you found the cases, now you apply to the facts of your problem or of the issues. Now let's get to some practical suggestions, okay? I know this might sound a bit obvious, but I promise you, get this wrong and you get into trouble. Firstly, give yourself enough time to get to the exam venue. Please find out where's the venue, check the Google Maps, see that you're not going to get lost, arrange your transport on time, get to the venue on time. Get there early, sit down, relax, have a chat with the others, and just relax. Make sure you have all the required documentation to show that you are a registered pupil. They will check this, okay? It's a security requirement. You would have been told what documentation you need. Make sure you have it. Make sure where an original is required, you have it, okay? Simple thing like having reliable writing materials. Carry spare pens. A ballpoint pen can dry up, and now you haven't got a spare pen, so you look frantically to see if someone can lend you one. Take a few pens along. The idea is not to create panic for yourself. That's the point. Okay, don't get into a panic on the day of the exam. Okay. Now, the exam paper itself. You must be organized in the way you approach the writing of an examination. We suggest that you read the paper end to end. Starting from question 1, read it through to the last question. You will be given time to read. So you needn't rush it, okay? Read it. And read actively. Apply your mind to what you're reading. Which questions carry how many marks? You must use this to plan your approach. For instance, you cannot invest a disproportionate amount of time on a simple 5-mark question, okay? And then you end up with not having enough time for the 15-mark question. I mean, that's stupid, okay? So work that out. And dispose of those questions that you can answer easily, get them out of the way. So you rank your questions according to what you can dispose of easily. This question I can understand. Okay, I know the answer to this one. Get it out of the way. Okay, and please label your question accurately. Question number. Put it at the top, underline it, okay? Then begin with the first question according to your ranking. Okay. And when you write your answers, as a lawyer, we teach you to write using headings. It's recommended that you use headings. It's very persuasive. It's part of persuasive writing. Never number your headings. That causes confusion. Okay. Put a heading, don't number it. Number the paragraphs in your answer. Okay. You'll cause less confusion. It's a good idea to read the question again before you answer it, because it's crucial for you to understand the question. Remember Einstein's definition? The question must be understood. This is the first rule. If there's any misdirection around this, any misdirection will result in a problem. It's going to be fatal if you give an answer, halfway through you realize, oops, this is not relevant to the question. So what happens now? You have to start again. You waste time. You run out of time, okay? And a good technique, when you read through the questions, you rank the questions in the order in which you want to answer them, then stick to it. The one mistake many people make is that they've ranked the questions. Now they start with the first question, start writing and decide, I'm not sure I'll get through this one quickly. Let me go to the next one. So you go to the next one. And so you sort of leap around between questions. And that's just a waste of time, okay? Make a selection, rank the questions, and stick to the ranking. Now, here's something I wrote in bold writing. Write legibly. The examiner must be able to read it. For God's sake, take this seriously. Serious. This is serious, okay? If you write badly, it counts against you. Remember, examiners are human beings. They have to mark hundreds of scripts. You know, my experience is when I get a script and the handwriting is so poor that I struggle, it becomes an effort. You need to put in so much effort because now I'm concerned. I can't really work out what this word is. Now I'm trying to work out the context because I'd hate to fail someone because I couldn't understand the writing. Then you get someone who writes beautifully. And it's a pleasure. It's like a breath of fresh air. Also, I'm not being sexist, but the women tend to write way better than the men. Okay? I don't know why the men all write like police officers, you know, and magistrates. They write like that. Please don't write like a police officer or a magistrate. Okay? Try your best to write legibly. It matters. Always use numbered paragraphs in your answers. It works. Write in plain language, and where applicable, use headings. And as lawyers, there's one thing that matters to us. You'll see it in the golden rule of evidence. It's called relevance. Everything we do must be relevant to a point. It must be relevant to an issue. Whatever you write in your answer must be relevant to the question. And answer the question and do no more. We don't reward you for length. That you can take it. You can write 3 pages and fail. Someone can write half a page and score 80%. Answer the question, do no more. Length is irrelevant. Spend time reading your answer, correcting errors, okay? Instead of wasting your time with other things, read your answer again. If you feel you cannot write anymore, and that happens, you've experienced this at university already. You've got a question, you answer it, and you can't say anymore because you've exhausted your knowledge. Now, the worst thing you can do is to sit there and chew your fingernails and wonder what else can you write. Well, you don't have anything else. Move on. Move on to the next question. That's the way you'll manage your time better. Now, there's one thing I noticed while marking papers and moderating papers. A number of pupils write an answer, flip over, and they leave a blank page, turn the page and write the answer in the third page, basically. So there's a blank page between. You know, one of the markers didn't realize that the pupil left a blank page and didn't flip over to the next page and gave the person naught for the answer that was in the next page because they didn't read the answer. They thought that's the end. If you feel you have to leave a blank page, take your pen and put a line through it. Then the examiner knows there's the answer on the next page, okay? Now your answers must be reasoned answers, okay? This is vocational skills. You will get a set of facts. You must solve the problem and present the answer. Now, here's the trick. Always read the facts carefully. If you rush through the question, if you rush through the facts, you are going to be misdirected. Read the facts actively, jot down the main points as you see it, then present your answer based on the main facts, the main points. I always tell advocates, when you've got a legal problem, the answer is in the facts. It's inevitably in the facts. What you then have to do is find the legal rule that supports that answer. Now you're being a good lawyer. If you can do that in your exams, you pass, okay? Think about what you write. What am I writing? Is it relevant to the question? Am I answering the substance of the question? Have I made the point? Writing an assessment of your vocational skills involves applying your mind. Don't try and think of what you swatted. You're not being a lawyer then. You're being an idiot. You need to understand the facts first. Apply your mind to the facts first. Then look at the law. Then present a reasoned answer. Now look, in every paper, we give you what we call freebies, you know? What are the alternate convictions in a charge of murder? I mean, it's easy stuff. We'll give you 3 marks for that. Okay, these are freebies. Doesn't need much thinking. You can get this, it's 3 marks. That's why we call it freebies. There are always a few of those in the exams. But for the rest of it, you'll have to apply your mind, okay? Your answers and the content of your answer must be relevant. That's another way of saying answer the question. Now, obviously, if you don't understand the question, you can't answer it, okay? You will not get questions that you don't understand, okay? Understand the question, answer it. If you exhausted your knowledge, stop. Answer the question and do no more. Now, let me talk about you as a person. It's very important to look after yourself, not just for purposes of exams, but as a practicing lawyer. You have to take care of yourself. Self-care during exams is absolutely vital. You must get enough sleep. This nonsense of taking a stimulant to stay awake to study, it doesn't work. I don't know why people do that. I know people who go buy a 6-pack of Red Bull and put it there on their desk, and they sit there through the night swigging Red Bull. And when they get to the exam, they're so bloody exhausted, they can't remember anything. And by the way, you will not be allowed to take a can of Red Bull into the exam room. So I'm warning you, get enough sleep, eat well, and please have a good breakfast, man. That's so important. I know I sound like your mother now, but you have to have a good breakfast. And throughout pupillage, you're supposed to be keeping fit. You have to exercise because it's one way to manage stress. This is a stressful job, okay? You need to exercise. You need to keep fit. You need to eat correctly. Good mental health and physical health will enable you to focus. You'll manage your stress better. You'll be calm. And most importantly, you'll learn to use a reasoned approach to all your problems. That's what being a lawyer is, a practicing advocate is about. And you need to back yourself. You need some confidence. And what gives you confidence? Preparation. Good preparation and understanding of what you're doing. Wait till you have to do your first opposed motion in the High Court or your first trial. You'll be terrified the night before. It's worse than sitting an exam. But if you prepared well, your training will kick in and you pull it off. You want to stay positive, walk into the exam room with confidence. I know people who walk into exam rooms and they're all over the place because they're in a state of panic. Doesn't work, okay? You have to back yourself. I want to give you one piece of advice. And please, if you're going to be a good lawyer, take this advice. Otherwise, don't bother, go and open a Chisa Mnyama somewhere. What you should do is improve your literacy skills. Advocacy requires fantastic literacy skills. Where do you get it from? Read a lot. Read lots of books. Read at least a book a month. Not work. You'll do a lot of reading, judgments, statutes, affidavits, heads of argument. That's your job. Read a book a month over and above that. You should get through 12 books a year. In fact, I say you must go through 12 books a year. Your ability will go through the roof. You'll surprise yourself. That's what you need to do. Well, good luck to you from all of us at the LPC. If there are any questions, I'll take them now. Were there any questions?
Yeah.
Good afternoon, Advocate Hussein. It's Tim Nkosi here.
Yeah, Tim.
Yes, we have a couple of questions. I'll start with those that were posted on our Q&A.
Mm-hmm.
The first one, good day. I just want to ask if a half mark will be awarded in the exam, or will be informed of this fact if applicable to a question.
We don't. We try and avoid awarding half marks. Very rarely will there be a half mark. And if a examiner awarded half mark, the moderator is going to look at it and say, "Why did you award half?" Awarding this is vocational skills. It's not swatting, so we avoid the half mark. Yeah. Next question.
Okay. During the first 15 minutes reading period, are we allowed to make side notes on the question paper to
Yes.
refer back to when attempting the question paper?
Yes. In fact, I encourage you to make side notes. You know what's the benefit of writing your points as you go? Is that it forces you to read actively. You're now applying your mind. There's nothing like writing a note to engage your mind. And that's not a bad thing. Next question.
Okay. Can it be clarified if the curriculum, the syllabus, and the reading list are the same document, please?
Well, if you saw the way it's published in 2 columns. The left column is the syllabus. The right column is the reading list. So that's how you should have received it. It was gazetted in that way. All right. Next question.
Is there a reason or a purpose behind scheduling 2 exams on a single day and 4 exams back to back?
Yeah, nothing wrong with that. You should be used to writing more than 1 exam the same day. It happens at university. Also, you know, if you're going to have only 1 exam a day, that becomes a logistical nightmare, and it costs a fortune. You have no idea how much money the LPC has to spend on exams every year. It just takes a chunk of their budget. So if we're going to have an exam on different days, it means hiring the premises. We need to appoint the staff. That's all the administration, the secure delivery of question papers. It's got to be done on 1 day. And, you know, at university, you wrote 2-3 hour papers in a day. When I wrote my board exams for when I qualified as an attorney, we wrote for 6 hours all the papers in 1 day. And if you failed 1 module, you came back and wrote the whole thing again. Things are a lot easier now. Okay, next question.
Yeah. If I provide case law which does not form part of the reading list which I use in an answer, will this be considered during marking, or it is outside the scope?
Oh no, no. Look, the reading list is there to guide you, because you know law, as I told you, is vast. We need to, for purposes of an assessment and the prescribed coursework, we've got to give you the cases to read. But if you quote a case that's not on the reading list, as long as it is relevant, we will give you marks for that. Okay. Next question.
Okay. Can I please get clarity on what is meant that we should not make up facts? I've seen past papers on motion court or trial court where we are asked how we can plead or improve on the pleading.
Yes, no, hold on. We set papers. You will see from the past papers, you are given a statement of facts. An attorney comes to you and says, this is what my client has experienced. Just stick to those facts. You don't need to make up any more facts. Where we think you should make up facts, we'll tell you. You may make up facts. But we don't have questions like that. I can remember that much. Yeah.
Okay. What books are we permitted or advised to bring into the paper 5 exam?
It's an open book exam. I don't think the LPC exam puts a limit, a ban on certain books like the JSA exams do, or the GCB exams do. But you know what? You will not need a lot of books. What you will need is the ability to understand the question and draft on your own. That's what we're looking for. You know, when I was a pupil, we wrote our exams in a library, like this one I'm sitting in now. And you were expected to do a whole lot of research and so on. And we wrote long. We wrote for 6-7 hours. We've cut it short now. So you don't be under pressure to carry a lot of books into the exam room. And besides, if you do take a lot of books in, one thing inevitably happens. You run out of time. You'll find that you can't answer some questions because you spent a whole lot of time researching books, and you're going to get naught for those questions. Okay. So don't let that be a problem for you. Okay.
Okay. All right. Will there be a space for us to study at the venue during the break between the 2 exams?
Oh, well, I'm not sure. Hey, maybe maybe Margaret could answer that question. Margaret, are you still on? I don't see her name.
I'm still on, Advocate Hussein.
Yeah, can you answer that question?
Can they please repeat the question?
Question is, will there be place on the day they write 2 exams on the same day? Will there be a space for them to sit and study?
No, sir.
No, okay. By the way, you shouldn't be looking for space to study on the day. Finish one paper, go and relax. You should be relaxing, chatting to friends, you know, and then you write your second paper. I mean, how much can you study in the short time? Next question. Is that it?
Okay, this goes to, I think this is directed to Maggie. Peoples from Basariba Mulawu would have not received any emails about the format.
The exam format is on the LPC website, and it was also published. No one was sent a specific email. Thank you.
Okay, thanks, Maggie. Where can we access past papers? They are currently not available on the LPC website.
Margaret, that's your question again.
It is on the LPC website. This has been published. Thank you.
Right.
Okay. Are we allowed to put bookmarks in our books for easy reference in exam 5?
Oh yeah, you can use bookmarks. But you know, I don't know what purpose it's going to serve, but if you tore off a piece of paper and marked it, it's fine. It's not gonna be a problem.
Okay.
Yeah.
Can I get clarity on the code of conduct?
Yeah, here it is. It's published by the LPC. During your pupillage, someone must have given you a copy. They're available. Go to your pupil master, I'll give you a copy of it.
Okay. Is reference to advocate in a question in these exams different from reference to counsel?
I don't get it. Advocate and counsel are used interchangeably. Means the same thing.
Okay. To confirm, are only the listed paragraphs of the code of conduct examinable?
You see, you must read it, read the code of conduct, and be smart about how you read it. The code of conduct is for the legal profession. And in the same code of conduct, you will see codes that refer to an attorney's practice and those that refer to an advocate's practice. You need to know the advocate's practice. You don't have to read the whole code. As I told you, it's quite a big document. So confine yourself to just what's applicable to advocates and you'll be fine.
Okay.
Right.
Is it advisable to write back to back or leave the back page open?
You're supposed to write on one side of the page. Okay? So you're not using the back page. So write on one side of the page. I think those instructions are there.
Okay.
Okay.
Okay, we seem to have dealt with most of the questions.
Good. Okay.
Okay, here's another one. Are we allowed to take a pillow with, oh, come on, a pillow within 5-hour exam or snacks?
A pillow.
Yes, a pillow.
Oh God. If you want to take a nap, don't stay at home and sleep. I think you got a bad back and you need to put it on the chair. That's fine. Nobody's going to object to that.
Okay. Is litigation skills book allowed?
Litigation skills. Which one? Marnowick's book.
I think that's the one, yeah.
Yeah, you can take that in. Yeah.
Okay. Okay, here someone is talking about the dress code. He or she needs to know about the dress code.
Well, there's no specific code. What I suggest is you dress very comfortably. Loose clothing, all right? No one's going to check your sense of fashion. Just be very comfortable. That's all I can advise you.
Okay. All right. I think
May I
think
also say they must be very decent, Advocate was saying.
Oh,
Comfortable
no.
but decent.
Mini skirts and fishnet stockings are not allowed. Okay. You need to be conservatively dressed, but just be comfortable.
Okay.
Right.
I think this one is for you, Maggie. Are the 2024 and 2025 exam papers available? Confusing.
Please
though.
visit the LPC website.
Okay. All right. I think we seem to have dealt with all the questions.
Okay. Thank you for attending, everyone, and good luck. And I wish you well in your careers. It's a fabulous career. There's some hands gone up. Cobus, Justina. Could
Advocate Hassan, I'm not too sure whether they'll be able to answer the questions verbally.
Yeah, just ask her, can you unmute them?
Shoni, are we able to unmute them?
No, I don't think we can unmute them, Babno. I don't
What
think
they
that's
can do
how.
is send their questions through to Margaret. If they're relevant, we'll answer them.
Yes, can they please send the questions to info@lpc.org.za with a clear heading that it is for the pupil examination. And if there's questions that Advocate Hussein is addressed to, I will send them to Advocate Hussein. If it's questions that we can deal with the LPC, we will deal with it. Thank you very much.
All right. Okay. All right. Well, I was about to say, wish you well in your careers. It's a wonderful career, but it's up to you. It's not a profession for lazy people. It requires a lot of hard work and application, everything you do. It's not an easy profession, but get it right and it's highly rewarding. Get it wrong and you're going to end up drinking. It's simple as that. Okay.
Advocate Hussein, if I may interject, sorry about that. We seem to be receiving a couple of comments here saying that they are unable to get the previous papers from our website. So I think maybe for that they'll have to make it directly.
Yeah. I don't have past papers available, so it's at the LPC. It may be a question of getting to the correct site, or but it's available.
Advocate Hussein, maybe they can go on the website and then they can just go to the section that says advisory and notices. It should be there.
Okay.
Thank
Good.
you.
All right. Okay. Shall we end the session then?
Here's another one, just the last one, Advocate. Is Van Black book allowed for paper 5?
It's what?
This is the book, Van Black.
Oh, Van Black's book on drafting.
Yeah, is it allowed for paper 5?
You can take it in. Yeah.
Oh, okay, thanks.
All right. Okay, all right. Let's end the session then. Well, thank you for attending, everyone, and thank you, Margaret and Molefe and Teminkosi for arranging this. I'm sure it's been quite useful to you. And I might see you again in the future. All right. Thank you.
Thank you, Advocate.
Bye. Bye.
Bye-bye.